Definitely 1 minute more. I am ready. Please. Today's session, as we have most of us over here, very few of us are already exposed to patent law maybe, and some of them are from my own college who are in their first and second years of intellectual property law. Therefore, I will start with the basics first, and in this today's session only we'll go into the deeper parts of the exam, deeper parts of the curriculum. Okay, and slowly we'll get introduced. We'll start afresh, and I believe within these 7 days we will be able to cope up with the majority of the probable portion of the syllabus which can come in the exam. Okay, so let me be very clear. I'm not going to discuss everything in this couple of 7 days, but of course, yes, I am going to discuss only those parts which have the most possibility of being asked in the patent agent exam, which is supposed to commence on 8th of May 2022. So, okay, there are other participants still joining in. Okay, so I'm sharing my screen. So all of you can see my screen. Please confirm again in the chat box. In the chat box, please confirm. Is my screen visible? Okay, all of you please reply. Please reply. I want you to type. Please reply. The more you are active in these sessions, the more you are going to perform well in the exam. I am telling you, this is fact. Please reply. I want your fingers to be active. All of you, don't hesitate. And there are going to be some rules to attend these sessions. All of you, take it seriously. There are going to be some rules to attend these sessions. You are not allowed to attend these sessions with your mobile phones. You should attend this session only with your laptop or computer, whatever you have. Unless otherwise, if you don't have any PC at your disposal, then in that case, I understand you can definitely attend this session with your mobiles. But preferably, you must and should attend these sessions with your personal computer, either it is a laptop or a desktop. Fine. Then, if possible, all of you, as of now, get a pen and a copy. Pen and a copy or a piece of paper for today. All of you, please. Please, and I would like everybody's video to go on. Please turn on your video. If you have a pen and paper with you, all of you, please put on your videos. I would like to see everyone trying to get a pen and pad. I really appreciate Dr. Basu. He is a very senior person. He is a professor in one of the colleges from my own native state, Tripura. So if he can follow up, all of you, please show up and grab a pen and paper today, and please from tomorrow onwards, please dedicate a separate copy for this exam. This copy is gonna be your everything for the exam for the next 7 to 8 days. Don't write anything else in that copy. Whatever I say, you have to write only that in that copy. If not possible as of now, please ensure that you get a separate copy for these sessions from tomorrow onwards. Okay, otherwise you will start searching in different places, and that will just waste your time. And you can also not connect and coordinate with what you have learned before and what you are learning presently. So I asked all of you to please put on your cameras, please, for once. All of you. Please obey by the instructions. Yeah, thank you, Rajeshri. Thank you for putting it on. Mr. Navin, please be seated and make all of you comfortable at your end. Please be seated with a pen and paper, because you will need to write. You will need to write. If you write, you will remember. As and when you are discussing something, you will remember this particular moment in the exam itself. Even if you don't know the answers, you can guess the answers because you have written something. Okay, this writing will be in your minds. Okay, thank you. So, all of you, welcome once again to the Patent Agent Exam 2022. And after a big deal of time since 2020, finally I believe it is going to happen in reality. So yes, I am excited, and first of all I really apologize for the late connectivity with all of you, because I was really involved with so many things going on at my end, both professionally and personally, that I was completely tied up and could not dedicate separate time for teaching this subject for this particular exam, although I connected with all of you almost 2 months back. And if not 2 months back, some people are here, definitely they will acknowledge 2 years back, since 2020, right? So we will brush up all the things that we have learned before, and also for the new joinees, please don't get worried. I will start from the basics today. I'll really start from the basics today, because basics are always important. Basics are always important. If you feel that these are basic, these are not going to come in the exam, then please understand this basic knowledge, even if you know, but you hear from me once again, this basic knowledge is going to serve your purpose to attend the interview, the personal interview. Okay, in the interviews they will not ask directly the section wise based questions so much. They will just try to know that how much you have understood the subject as a patent. Alright, so thank you. Let's begin. I'll start from the basics. So all of you, those who know about intellectual property and patents, please be patient for some portion of the time. Okay, then we'll slowly realize that we are going into the deeper aspects of patent law in this session itself, and then we'll also hereafter we'll also continue to go deeper and deeper, and only specifically those portions which are important for the exam, right? There are only 7 days. I am removing the last 2 days. Within these 7 days, my plan of action is, all of you please listen carefully, my plan of action is daily 4 hours of sessions with me. In the morning 6 to 8, which will happen tomorrow morning as well. Morning 6 to 8, and at night either from 7 to 9 or 9 to 11. I will inform it every morning for the corresponding night session on that particular day. Okay, so I want all of you to think, drink, eat only patents for this next 7 days. Okay, nothing else. Understood? It is not a difficult exam at all. It is a very easy exam as compared to CLAT or CAT, CAT or CLAT, whatever it is. I find it easy, so you can also find it easier. I found both MBA exams, aptitude test, entrance exams very, very difficult, right? But I found patents very easy. So if I can cope up with patents, all of you are too much intelligent, I understand. So please pay attention. You will easily overcome this particular barrier in your life, and it will be there with you. It will be there with you forever. It will be giving you the importance behind your name wherever you go, on whatever professional scenario you are contributing either as a patent attorney or a counsel, or even not in the field of patents, as an academician also. So fine, so let's begin. बहुत ज्ञान हो गया, चलते हैं आगे. Yes. Yeah,
sir, just a thing, like, could you just repeat the timing once, or put it in the chat box? It will be easier for us to
I
keep
will
a track
inform
of it.
everyone by WhatsApp, don't worry, and also by email. Okay, the timing is gonna be 6 to 8 in the morning, and
okay, sir,
7 to 9 at night, or 9 to 11 at night.
For the upcoming 7 days.
For the upcoming 7 days.
Okay, sir.
Okay, I'm exaggerating myself. I don't know whether I will be able to do it really or not, but definitely I will try to do whatever I have said, at least for the next 7 days, even if it takes a lot of adjustment from my end, but the same thing I am expecting from all of you. Okay, so fine. Before we proceed further to take up this question, what is intellectual property, only those among these 22 people who are present here, except me, 21, not, sorry, except I am present in 2 systems, except me, 20 people are there. I want to know how many of you do not belong to Rajiv Gandhi School of Intellectual Property Law. Only those, please write their names in the chat box. Those who do not belong to Rajiv Gandhi School of Intellectual Property Law, IIT Kharagpur, them, please write their names in the chat box. Not yes, not no, write their names in the chat box, please. See, these are very important. This will make you enter the habit of writing. Okay, others. Sir, Dr. Samba, not no. I know you are not from RGS, but I want you to write your name. Write Samba Sividu, please. Please take this seriously. Please don't mind. I'm going to enforce certain things on you, because otherwise it is not possible to impart and inculcate the seriousness within us. Okay, so this is for an exam. This is not a mere capacity building session. This normal habits will make us do and practice what I want all of you to do. So please, all of you, please write your names. Devoshrita Boshak, Samba Sivudu, Ramakrishna, okay, fine. Shyam, Naveen, very good. Dr. Basu, you have not written your name. Please write your name. See, this, I have an idea who belongs to RGS and who does not belong to. But still I want you people to follow the instructions with folded hands. I'm telling, please follow my instructions. This is going to be useful. This is going to be useful. Please don't ignore whatever I say. Okay? Fine. So that means at least 1/3 of the section is not directly related with intellectual property. So I will take this for them. So others, please be patient for some time. What is intellectual property? Now let me say, property can be of 2 types. Okay, sorry, rather than property, types of property. First let me say, what do you call something as your property? What do you call something as your property? You can speak up. Any one of you can speak up anytime whenever you are seeing some question. It is open for you, all of you, to speak up at your convenience. Okay, don't hesitate to ask me anything in between. Otherwise maybe later on I forget to come back to you, get back to you. Okay, so I don't mind getting myself interrupted to take your questions, right? So whenever I say something as my property, that means that particular thing might have been created or purchased. Do you agree with me? Okay, sorry Dr. Basu if I missed you. I noticed that you have written your name. Thank you. Please don't mind. If something has been created, or if you have purchased it at an expense of your spending money, right? then that particular thing becomes a property. This is the basic jurisprudence of property, right? So here either you create or you purchase, and in both the situations there is some expense. There is some expense from your side. What is that? Your skills and efforts. Suppose if we go back to earlier times when we did not have these concrete homes, or even earlier, if you have to have a home, we have to construct a home. Earlier, even in my earlier generations, in my just preceding generation, my parents used to construct with their own homes where they used to stay. Okay, only a piece of land they might require to purchase. Then the entire construction activity, they used to make their own home. Those were huts, and everybody made up of bamboos and wooden, not wooden, yes, sometimes wooden as well, or bamboos, or the homes are made up of maybe what is it, earth, mati ghar, which is what we say in Bengali. So everyone used to know that skill. If somebody does not know how to create his own home, then he was considered a useless fellow. But that home became his own property because he created it, right? Or nowadays, if we come to getting a home, we have to purchase a home. Or all of us probably here in our generation might not be knowing anything of how to construct a home. It has become a specific skill which is being provided as a service by particular persons who does that particular job. Okay, so what I want to say here, property is property only when it is first created or it is purchased. So when it is created, you spend your effort and skills, or when you buy something to establish your ownership on the property, you spend your money. Anything for that matter. Others, please keep yourself muted. If someone is not muted, please keep yourself muted. There are some other sounds coming into the session. Please. Only if you have to speak up, please unmute yourself and speak up. Okay? Thank you. So, next thing I want to tell, as I was telling, creation of property. You have created a house of your own. But my next question is, can you always touch your property? Is it possible? I want people not from RGS to give answer to this question. Can you always touch your property? Whether you have created or you have purchased, can you always touch your property? Please answer. People who are not from RGS. Devasrita madam, Sri Lakshmi, please.
If it is tangible, then we can touch.
If it is tangible, we can touch. But that is not the question. The question is, can you touch? Yes or no? I'm not talking about tangible or intangible aspect of a property. Just a simple question.
Yes, we touch.
Can you touch your property always?
Yes.
Okay. Who said yes? Okay, Dr. Basu. Others, please. Devasrita. That's why I asked the names. Sri Lakshmi, so that I can connect with them directly in the chat box. Please answer. Either in the chat box or speak up. Mr. Shyam, can you touch your property always? Answer the question. It's a simple yes or no question. I will not proceed forward unless I get an answer from all these 4 people who have written their names.
Answer. Oh, badly.
Okay, great. The answer over here, every one of us here, Naveen, Khushbu, Rajeshri, you are not allowed to answer here. Okay? Anyways, you have answered. Sri Lakshmi, see, that's why I took all of you to the basics. That's why I took all of you to the basics. Everybody says, yes, I can touch my property. Yes, I can always touch my property. But the answer is actually no. It is not necessary that you can touch your property always. And that is where the intangible aspect of property comes in. And generally, intangible property, that means property which cannot be touched or felt, generally intangible property which cannot be touched or felt are created by you people, by the originator or the creator or the inventor. For example, let us take Dr. Basu here. He is a professor here and he might have done some research in his career in particular specific technical field, right? But there, while doing that research, he has spent his valuable time, skill, effort, intelligence. As I said, when you just going to the prior 4 to 5 minutes before this session, if you go there, I've been telling that people used to make their own homes. They used to make their own homes by themselves, by spending their time, effort, and skill. Right? They learned from their ancestors or neighbors how to tie two bamboos or make a mixture of earth and water and something else. So they performed that particular skill. Same way Dr. Basu, when he was doing his research in his career, he definitely spent a specific skill of his technical domain. He has learned something and then he has executed it. So lot of effort has been given as input, right? But only if he has taken the option to be recognized those skills as a property, then that kind of property becomes his intangible property. There is a reason why I'm not going directly to the words right now. I just want all of you to understand that every person they spend their skill and effort at some point of their lives definitely to generate something, but they don't get that particular thing recognized as their own property. And that is where the importance of intellectual property comes in. That is where the importance of intellectual property comes in. Intellectual property is a kind of property which cannot be touched. So it is intangible in nature. There is lot of inputs which has already given to it. So, but it is our failure individually that we did not give the recognition to those efforts, the skills, the time that we have spent in the nature of a property which we can utilize for our own benefit in the rest of our lives. Okay, so it need not be always your scientific efforts. There can be different nature of efforts which we will see in due course. Okay, yeah, so I really appreciate Rajeshri, who had actually related to property such as stock and stock market, because here I find some coincidence of my individual thoughts and with her individual thoughts. Okay, most of us, this is the slides prepared by me before only. Okay, why did I prepare this slide? Most of us, some of you might have been what, doing trading in the stock market, or if you don't do, all of us know that there is something called as share market. We can buy shares, we can sell shares. There are so many brokers available. The entire world is running in this, but through this share market only, the entire economy, right? But very few of us do realize, even people from the intellectual property field, professionals in the intellectual property field, very few people from the intellectual property field as well do realize that even basic shares of a company basically is a kind of intellectual property. Because can you touch the shares? Can you touch the shares that you buy? Answer, everybody now. Can you touch the shares that you buy?
No.
All of you, please, in the chat box, even if you know the answer, say it out loud, no, or type it out. I want the chat box running. Yes no करते करते देखना बहुत कुछ याद हो जाएगा. Okay, and this particular discussion will help you to answer some certain question that comes to you from any end during the interview. Okay, ये यही basics है. See, shares is also, what is share? Share is also a creation. It is a creation. Did you build the shares with cement and rocks and chips? No. Shares is completely a notional creation. Completely a notional creation. When one person right now, or more than one person, earlier one person was not possible, now something there is also called as one person company. So either one or more persons right now can create shares for their own company and then start a company, or both happen simultaneously. You cannot open a company unless you create some shares for yourself, not for yourself, sorry, for your company that you are going to incorporate. Okay, so when you two or more persons, suppose two persons are there, they say that we both agree to make 100 shares for us, each share of 10 rupees. That means the total value of our shares will be 1000 rupees. So what did I do here? I have attributed a value and notionally created a unit share for the purpose of making a company, and the value of those unit shares only starts getting increased as and when the business of the company is running in due course. The 10 rupees of each share becomes 12, 15,000, 2,000, 3,000, 7,000, 8,000, and then those each shares are again divided, or new shares are also created. New shares are in the beginning we started with 100 shares. Now these two persons who are the promoters of the company think like, okay, we are running the business good, we need more capital for our company, so let us do one thing, let us create more 100 shares. So it is completely at their own will, right? Of course there are regulations. I am not going to the regulations under the Companies Act, but it is possible if you comply with the applicable regulations under the Companies Act, then you can create as many shares as you can, and this is completely notional. You cannot you need not build it with something physical in nature. You create and you sell with your shares if you are doing good business on the name of your company, and the ownership of such shares determines the ownership of the company. So if you are buying very nominal portion of one single share, then please remember, even you are becoming an owner of the company to the extent of the value of that share. Okay, so that's how the entire world is running. So the entire world is running on intellectual property. That is the importance of intellectual property, but it is very seldom realized. Okay, so am I understandable till this point? I will directly go into the deep right now. Little. Was I understandable? Please. Was it interesting? Please type in. Was it interesting to know, or you knew it before? All of you. The more the feedbacks, the more it's encouragement for me. Okay, thank you everyone. Fine. So right now, as I was telling, shares is a notional creation. It cannot be touched. Okay, but it can be traded upon because it has a value. It has a value. That is the important thing. It has a value, and because it is a value, therefore it is given the importance of a property. Just like your house, just like your laptop, just like your just like your any other damn thing that you possess, your shirts, your wardrobe, whatever is there in your wardrobe, your new clothings, or your TV or your table or whatever, wherever you stay, everything has a value attached to it, and therefore it gets the importance as a property. And same thing is also applicable for intellectual property as well. Let us see how. Okay, so for example, this machine has its own cost, right? If you want to, this machine has its own function, probably to manufacture some product, but someone might have designed the property, someone might have designed the machine, right? So there is a value to that basic design itself. You can sell the machine separately, and you can also sell the design of the machine separately. Maybe the design does not have any newness in that particular property, in that particular design. What I mean to say, that the design of the machine may not be new to be eligible as a registration for the purpose of registration of any intellectual property, but still the design is a separate property which you can sell. Okay, the technology in itself is a property. Okay, so you must have combined and assembled different categories of machinery tools to generate this machine, and therefore you have thought a lot to understand the compatibility of each of its constituent components in this design of the machine, and therefore it has got a value which you can sell to any new business owner. Okay, let us go ahead. All scientific experiments that we do, we are, as I was telling, we are pouring in lot of, financially we are pouring in lot of value, because all the raw materials that we consume while doing any research has direct financial investment, as well as time and skill and efforts as well, which also has a value, right? For example, value. When I come to value, many of you must be having your own YouTube channel or Instagram channel. So many people has today. You can create your own content, and while you are creating your own content, you are getting more and more subscribers. Why you are getting more and more subscribers? Because your content has some value that your subscribers agree with themselves to invest their own personal time to look into your video, at least for 2 minutes or 30 seconds or even 10 seconds or even 5 seconds. They have the agreement within themselves that, okay, I will see this person's content, leaving other work, and of course investing time is investing value. The YouTube pays them, YouTube or Instagram pays those content creators periodically, because he has contributed in developing YouTube. Therefore YouTube pays them. The more you run YouTube, the more you run Instagram in your mobile, the more it generates business for itself, and that's how they recognize the content creators who create content in those particular platforms. So because they are generating value, because time is directly proportional to money, because those platforms, YouTube, Instagram or LinkedIn, whatever it is, they are generating content, so value is automatically generated. So you can register those values in the form of your own intellectual properties. We will see in due course. In your mobiles you have lots of apps nowadays, so all those apps have certain value. They have some particular function to do, right? If I want to order milk for myself tomorrow, I will do it through my app, because it is giving me convenience. I did not call and go for any particular see and search in the market, where do I find milk, right? So everything is, this convenience that it has poured into the app is realized as a value. So everything has a value. Either it is a content, either it is a artistic content or literature content, or it is even if you are performing some if you sorry, even if you are a chef for that matter, you are cooking well, you know how to cook well, you are, that also has a lot of value, right? So everything has a value incorporated within themselves, and therefore these are all kinds of intellectual properties. Okay, so this is what is intellectual property. Any particular thing which cannot be touched, any particular thing which cannot be touched, or any particular thing which cannot be felt, but still it has a value within themselves, which can be realized, which can be physically realized, that value in the form of money in your bank accounts, are eligible to be called as intellectual property. Please be known, I'm not referring to intellectual properties which can be registered as intellectual properties. They may be intellectual properties but may not be eligible to be registered as intellectual properties. So there is a difference here. And when I say registration of intellectual properties, okay, I've already, okay, I will discuss this. When you say registration of intellectual property, at that time we will have to relate to the existing legal setup that has been internationally recognized for those kind of intellectual properties which can be registered. Also may be referred as different kind of intellectual properties like patents, copyrights, or trademarks, like that. So just brushing up, what is an intellectual property? A thing which has a direct attribution of ownership, okay, has some value attached to it, cannot be touched in essence, but it is intangible in nature, which is most of the times created by the owner, or else you can also buy and sell that particular value. We will see later on. If not, you create intellectual property, you can also buy intellectual property, just like any other things that you buy from the market. Okay, intellectual property which can be registered has some tenure attached to it, has some time limit attached to it, for those intellectual properties which can be registered, and those tenure is subject to the rules and regulations that different countries have framed for themselves. Okay, and as I was telling, intellectual properties can be an asset, can be pledged or mortgaged. That means you can buy intellectual property, as I have been telling you just a minute back. So this is the basic concept of intellectual property. Whatever I have said you right now, if you had been listening to me properly, I am very confident that this particular, till this moment, whatever I have discussed before going to the patent agent exam, this is going to help you, answer some of the other questions in your patent agent interview. Okay, fine. These are some basic things which I'll quickly brush up. Intellectual property, when I say intellectual property, it is different from other kinds of rights associated to intellectual property. Okay, before I go to this comparison, if there is a property, let me just make a statement. If there is a property, there are rights as well as liabilities automatically created for such property. For any kind of property, there are rights and liabilities getting associated to it. Just give me a moment. sorry for the interruption, sorry. Okay, when I was telling, if there are rights, so if there is a property, there are rights associated to the property. If you buy a pen, okay, even if you buy a simple anything for that matter, so for example a pen, okay, then it becomes your responsibility to make the pen, keep the pen with you always, so that you can avail the pen to write something at your disposal. If you forgot a pen in your home and in your office, then you cannot use that pen, right? You cannot exercise your right. So what I mean to say is, at the simplest form, anything that you possess, you have the responsibility to maintain it, or do something or do not do something with such kind of property for your own convenience. Okay, carrying that pen becomes a responsibility to whichever location you go, so that you can use your pen. So that is also a responsibility. If you don't fulfill that responsibility, then you become pissed off with yourself. Oh, I forgot my pen today. Please get borrowing a pen. For example, in the exam itself, if you forget a pen, today it is this is the nowadays we are so much into typing and doing online stuff, everything in the computer, that writing will itself become a very difficult skill going forward, right? So anyways, what I was telling is, all other kinds of property all kinds of property has rights associated to it, but the rights associated to intellectual property and rights associated to other kinds of property or other rights in general are different from intellectual property rights. Okay, so intellectual property rights are applicable and available exclusively only for you and not for others. Whatever intellectual property rights you have, they are applicable and can be exercised only by you and not by others at all. Whereas other rights, if we see, which are mostly the fundamental rights, as particular examples that I have been quoting here, those are commonly available to all. But when it is intellectual property rights, it is a very specific right which has been granted only to you, only and only to you, and that is why you can exploit that right to your benefit, right? So what are intellectual property rights? Intellectual property rights are the rights which is kind of a negative right. I am not going to the legal and very deep into the jurisprudence of the meaning of legal negative right. There are other aspects of a negative right as well. But at the simplest form, when I say intellectual property rights, it is a right to stop others doing something, from doing something. And yes, intellectual property rights is subject to lot of regulations for that matter. Okay, some intellectual properties may not be subject to any regulations, but some intellectual property are definitely subject to so many regulations. And it is a kind of social contract. It is a kind of social contract. Why it is a kind of social contract? Can anybody explain? From people who know about patents, why intellectual property is a social contract? This question can be asked in the interview. Let me tell you. Anyone? I want anyone of you to come in, pitch in here.
Shall I try?
Yeah, please tell me, please.
Because when patent is done, it is a right given for a stipulated time. Because the benefit of the patent should be available to the society. In the ultimate, it should be available to the society, but for the time being, who is creating the patent, the product, the tangible product or intangible patent product, should get the advantage of the product, but for a particular period of time. After that, the benefit should go to the mankind. So then it becomes a social. This is a social kind, maybe.
Yeah, we are exactly to the point, but uh, okay, thank you for the answer. It's exactly the correct answer, but let me simplify it further for others. Yeah, Oritra, you want to say something?
So I think since there are chances, like sometimes it so happens for patents that the inventor is blocking others from getting into the market, so they patent something. So in that cases, compulsory licensing does play a major part in doing it. So that's kind of a social contract that benefits the society at large.
Okay, that is one more aspect to it. A further aspect to it. Great, thank you. Correct answer. But let me start from the beginning. As I was telling, contract, social contract. What does it mean? Contract means I give you something, you give me something, right? It is a
It is a deal.
it is a deal, right? It is an exchange of some or the other thing between one or more persons. Earlier, we did not have currency. We had the barter system. If you go date back to earlier times, we had the barter system wherein if I have 1 kg of mango and you have 1 kg of rice, fine, you give me rice, I'll give you my mangoes, right? So somehow there is a mutual agreement between two parties to perform a set of activities wherein benefits flow to both the parties from the opposite party. This is the general literary meaning of a contract. Okay, so if I say like that, then tell me, when you are seeking for any intellectual property rights, what you are giving to anyone, and who is that anyone, and what is that anyone giving to you? Now tell me, who is with whom, if you are having an intellectual property right, with whom you are entering into a contract, who is the other person? As I was telling, contract involves at least more than one person, at least two persons. So if you are the one at the one person, if you are the person at the receiving end seeking for an intellectual property right to be given to you, then who is that person going to give that intellectual property right to you? Simple answers.
Yeah.
Yeah, who will give that intellectual property right to you?
The
You will
patent
get the
office.
right, but who will give you that right?
The patent office.
Okay, others please answer. Experienced people, you can say me the exact answer. Patentee is going to get Rajeshri. Patentee is at the receiving end. Who will give to the patentee is my question.
The government.
Correct answer, the government. Thank you, Devanjan. Patent
Welcome.
office is also correct answer, but the appropriate answer is the government through the
Through the
patent
patent
office.
office.
Through
Yeah.
the patent office as a representative of that government. Okay. So if there is a patent office, fake patent office, and gave you some right, see, it is your trademark right, your intellectual property right, and then you want to go and enforce it, and the court does not recognize that at all. It happens. When you will practice, you will find so many, you will go to so many websites which will feel like they are the intellectual property websites of that particular government, and you pay them fees also over there for publishing your patents or trademarks, but ultimately it is not going to give you something at all. So that is why I want you to say the government. The government will give you that intellectual property right. And then what do you give back to the intellectual property to the government? If the government is giving you the right, what do you give back the government? Tell me, experience
The
people.
disclosure. Disclosure of the invention.
Okay, disclosure of the invention is with respect to the patents. Simplify it. I am not going to the patents right now. I am talking intellectual property rights in general. Simplify it. Simplify your answer. Speak up, others, other than Devanjan. There are people who are already in RGS in second year. From second year, they can answer this question. See, these are simple questions. If you don't answer, if you don't speak up, yeah, tell me.
A innovative product having applications for society.
Okay, fine. I really appreciate Dr. Basu for his repeated contributions and taking part in the session. But others, juniors, first years, second years, please speak up. No difficult question will be asked in the interview, I am telling you. They will ask you the basics only in the interview. What will you give back to the government? Okay, you can say with respect to patents only.
So basically it is fees and the commercial value.
Okay, fees is one part of it. Okay, great. Even I did not
And
realize.
the commercialization of the product.
No, not for commercialization.
So the revenue will be generated through that idea of the patent.
No, not for the commercialization. Fees definitely is the answer. You will give fees to the government, but you are also giving something else. You are also giving something else along with the fees. Fees is for the purpose of registration. It is the generation of revenue for the government, but not for the commercialization of that invention. Commercialization is your will. Government will not come behind you and ask you to commercialize. It is up to you. If you don't commercialize, then it is again the government will be concerned. If you don't commercialize, let others commercialize. That is what exactly is compulsory licensing. But what you will give back is the
Innovative intellectual property, I think.
Is the know-how. Like
innovative intellectual property. The new skill or new.
Yes,
thing.
Exactly. A new skill which is not known. The secret. You are disclosing your own secret for which you are getting the right. That information in patent terms, it is, please answer this way, the enablement of the invention. All of you, the more appropriate you speak during the interview, the more marks you get for the interview. A question asked in the interview, from that question you can drag 50 marks from a single answer, or even you can drag 1 mark from the same answer. Both the answers may be correct. Both the answers may be correct, but while we are discussing, you will get to know what to answer to what kind of questions. So if we say, if the interviewer asks you patent is a social contract, then what you should, and if they ask you what is you giving back to the government, then you should answer, I am giving the enablement of my invention. Enablement. Disclosure is fine. Disclosure means enablement. The more appropriate term, the more good, the best term to that particular answer is enablement of my invention. Okay, then the examiner or the interviewer will be impressed. Arey wah, yes, said the best possible answer to the question. Okay, speak legally. Definitely slowly you will get into those terms. So enablement means suppose, or even if you don't get the exclusive right in this deal, the government will enforce you to say and let others know how to practice the invention. Okay, to say and let others know how to practice the invention, or how to execute, or how to make, or how to access the same nature of rights, even if those rights does not become exclusive to you. That goes into the deal. So the government is always at the upper hand. It has the choice. Either it will give you the exclusivity of the rights, or it may not give. But you have to inform. You have to disclose whatever you have with yourself. So this is the deal. This is the expense from your side to register the intellectual property rights for yourself. Okay, again, to one word answer is the enablement. You are giving away the enablement of your intellectual property to the government. You are also paying fees to the government, and government is giving you the rights associated to that intellectual property on the premise that the subject matter of that particular right satisfies some minimum eligibility criterias of that intellectual property right as prescribed under the law of that government. The law says what are the eligibility criteria for that particular intellectual property right. So only if you satisfy those eligibility criteria, you get the exclusive right in your favor. Otherwise you will not get. You will apply but you will not get. But you have to give back the information on that right. Okay. So if you want that right, you are always at the, it is always, you are always on the other side of the table. You will be negotiated upon. You cannot negotiate much. But if you pass the patent agent exam properly, you will learn how to negotiate better for the right that you are seeking on behalf of your clients. Okay, fine. So again, these are basics. I am slowly deep going inside. Patents, copyrights, trademarks, geographical indications, designs, these are all different kinds of intellectual property rights. Those intellectual property rights which can be registered. You will not find share, as I was discussing some moments back. Share is no kind of intellectual property rights, as you can see in this particular screen. You cannot put shares anywhere, because share does not form the subject matter of any of these kind of intellectual property rights presented in the screen. Each of these intellectual property rights has some or the other specific subject matter attached to it. There is no connection of the subject matters of patents and subject matter of plant varieties. There is no connection between the subject matter of patents and geographical indications. Each and everything has their own separate, mutually exclusive nature of subject matter. Okay, and registration of intellectual properties in the form of patents, copyrights, trademarks, or designs, or any one of those, are based upon the underlying subject matter for which you are seeking that intellectual property right. For example, if your subject matter relates to some technical inventions, anything with applications of science and technology, not science or technology, applications of science and technology. If anyone asks you in the interview, what is the subject matter of patents? Simple question, and 99 among 100 people will say science and technology, and that is a wrong answer. And that is why I am taking this session from the basics. Some people I saw that they have already left because they found this session already very primitive. I am not telling anything offensive against them. Of course, it might be a waste of time for them. I understand, because they might be knowing all those. But still, at the point of time, if I still ask them what is the subject matter of patents, possibilities are there. Even they say it is science and technology. That is a wrong answer. You should say applications of science and technology is the subject matter of patents. Science and technology are never patentable. Science and technology are never ever patentable. Those are specifically categorized as not patentable subject matter in the law itself. In the Patents Act of all the countries, science and technology are not the subject matter of patents. Only applications of science and technology are the subject matter of patents. Okay, if you have some applications of science and technology, those specific applications of science and technology which are new, which are not known to the entire world before you have presented it to the entire world, only those kind of applications of science and technology are the eligible subject matter of patents. Okay, fine. So this was about patents. Any kind of literary work, any kind of music or dramatical performance, cinematographical films, all those nature of things are the subject matter of copyrights. Brands, logos, I'm skipping, these are the examples. Okay, so for example, anyone, all of you can say what are those brands, right? Can you say what is this brand? This one? See my mouse.
Titan.
Correct. Titan. So fine. So what? And then can you say this one? Others? Assam Muga silk sari. Okay. What is this? What is this kind of an intellectual property? Assam Muga silk sari. Is it a trademark or geographical indication or something?
Geographical indication.
Yes, it is geographical indication
GI.
because you can say. Please continue.
It is a GI, this geographical indication,
Why? Why it is geographical indication?
because it is related to Assam only. It is Assam is known. It is known for Assam is known for this one. This is
That means
product of Assam.
a product of Assam. Yes, that means product of a specific geographical location only.
Yeah.
Okay. So therefore, it is a geographical indication. So that's how subject matter of each and every different kind of intellectual properties gets differentiated from each other. Okay. I'm not diverging into other forms of intellectual property anymore. Please understand, for this particular exam, the question that you may face, also you can face questions from others. I mean, they may ask in general questions from other fields of intellectual property also. So please, if you remember this slide, you can say what are the subject matters of different kinds of registrable intellectual properties. Okay, like trademarks relates to brands and logos. Geographical indications, the subject matter of geographical indications are any particular product. Can there be service also? I don't know. Product, I am not that conversant with the geographical indications, to be frank enough. Maybe a service as well, which relates to only specific one geographical location. This is the ultimate criteria. It should relate to some geographical location. Then it becomes a geographical indication as an intellectual property. Literary, artistic, dramatical, musical works, or cinematographic films, sound recordings, these are the subject matters of copyrights. LADMS, literary, LADMS, okay, literary, artistic, dramatic, or musical works. Then sound recordings, cinematographic films, only these. Okay, then if you answer like this, then they will understand this person knows about intellectual property. Otherwise, people will say music, they will say songs, they will say poems. Okay, when you go to the interview of a patent agent exam, you should not answer like that. You might be answering correctly. As I was telling, from one question you can procure 50 marks, or from that specific question you can also get only 5 marks. So it's up to you.
What is the word? LADMS.
LADMS. Literary, artistic, dramatic, musical. That is LADM. For S it is sound recordings.
Okay.
And cinematographic films. Right. Plant varieties are those intellectual properties wherein a new breed of plant is generated. Okay. Even I am not that so conversant with, in fact, not at all conversant with plant varieties and geographical indications. I have not done a single assignment on plant varieties and geographical indications till now in my last 12 years of career. Then designs. So designs is, see, paper boat. I have given this example. Paper boat here.
I have one question about GI. Who can apply for GI? Because for Assam Mugasi, for example, or Darjeeling tea, if it first GI in India. Now for the product, who can go for the GI?
The legal answer to your question is association of persons.
Okay.
Okay, but I cannot explain much on it.
Okay.
Very truly. Okay, I cannot make you understand how do you actually form that association of persons before you apply for a GI. As I said, I have never applied for and I have not worked on GI at all. Okay,
Okay.
so but for designs, let us for these designs, yeah, design. What is the importance of design? I wanted to just explain that. Inside paperboard, there must be a very generic composition of a fruit drink they might be selling, but still you may opt to grab a packet of paperboard when you are roaming in the supermarket rather than grabbing fruity or rather than taking any other um fruit soft drink. Why? Because this particular design of the paper cut into a particular shape, this might impress you. Okay, and that's how you are categorizing and appealing to your potential customers. That is why design has a specific aspect because it is generating a value in the minds of your customers through its own aesthetic nature of the product, or even I don't know, aesthetic nature of the service. I don't know. It's not, no, it's not possible. In designs, it's not possible. It's only for the products. There has to be an article which can be manufactured. Okay, so whatever the article you sell, maybe they don't qualify for patents, maybe they don't qualify for any other nature of intellectual property, but still with some or the minimum tweaking of that particular article, you can make yourself eligible to file a design on that particular article as a registrable intellectual property to make yourself unique from your competitors, right? So these are the basic subject matters of all the intellectual properties. Okay, so then we will start directly with the subject matter.
I have one question.
Yeah, please.
Designs and design patents both are same.
No, Sri Lakshmi, design and design patents are different. As you can see here, in some countries, designs are also known as design patents. The words are interchangeably used. Okay, some countries it is also called as utility patents. Okay, or some other wordings they may say, uh, they might have attributed in terms of legal definition. Okay, so but sorry, I wanted to say is the basic subject matter difference is that only, wherein any nature of aesthetic incorporation to any particular product that makes it significantly different from other products of the same nature, those particular incorporations which should not have any relation to the functionality of that particular product, those particular incorporations are registrable as designs. In India they are called as designs. There is a separate act for it called as the Design Act 2000. Okay, under this Design Act 2000, those designs are registered, like model of each particular car of all the companies, Maruti Brezza, Suzuki Brezza, or from Maruti 800 or whatever, any car, Hyundai Santro or Hyundai Verna, all the cars look different. Maybe the engine is same inside. Okay, the Honda engine is same in each of its Honda's cars, but the names are different because they look different. They create a different kind of an impression, and they may give different additional facilities in different model of cars, but the engine remains the same, right? So because they are creating a differentiation through their outward shape of its appearance, so they may be registered separately as designs. Okay, so designs are not the categorization of patents at all. Okay, that is the concept, you please remember. And this design is variously named in different countries. In India it is called as designs. Okay, patents is
Okay, sir.
uniformly named everywhere, but there are also different kinds of patents. Like for the criteria of patentability are minimalized, made nominal for some. For example, there must not be, as we'll see in due course, patents has something known as novelty, utility, and inventive step. These are the three criteria of patentability. But in some countries, you may get patents for without having any inventive step at all. Possible, might possible. So in those cases, they reduce the term of the patents. So it will be called patents, but their nature and the rights will be considerably reduced. So it differs from country to country, but still the wording will be used as patents only. But in designs, it is variously named in different countries. But designs are never same as patents. Okay.
Hi, sir.
Yeah. Please tell me.
I have a small question.
Yeah. Please tell me, sir.
Actually, I have an invention, but I published it in research journal. Invention that is published in research journal, but I didn't take a protection. I didn't take a patent. So that is not intellectual property.
Yeah, that is intellectual property.
That is intellectual.
Yeah, that is
Suppose if I
intellectual property.
published a research in research article, that's come under intellectual property or not?
The person who has published, did you publish? Who published?
I published.
You published, or some publisher published in their magazine or in their journal?
Yeah, I applied. He published.
Exactly. You did not publish, sir. That publisher
Yes.
published. Okay.
Yes.
So that
Yes.
publisher has the right, and while you have given the manuscript to him, we have signed some agreements. Definitely clicked somewhere that you are giving that rights to him to publish, unless there is a separate copyright agreement.
Okay.
Okay. So to that expression of your research, irrespective whether it is eligible of a patent right or not, expression of your research on papers as a manuscript or in a MS Word document is eligible form of copyright protection. Okay, is having a, by itself has a copyright, intellectual property right, associated with it. But you have given off your right to the publisher because you want that the expression to be published and made known to others. So the publisher will do it for you on the pretext, on the premise that you are giving that right to him. Okay. And sometimes the publishers may pay you, or sometimes you will pay the publisher. Depends upon the nature of agreement. If you want not to publish your scientific research or invention, you will ask, if some journal comes back to you behind you, I will publish it, then the table turns around. You say, why will I give it to you to be published? I will not give. Give me money, then I will give you, because I know how much it has value. Okay. So for that reason, yeah, tell me, sir.
So if my invention is applied to journal, that is comes under copyright. Same thing if I apply to patent office, it comes under intellectual property or patent, right?
It comes under patents, yes. See,
Okay.
all patent publications, all the patents that is written in the form of an MS Word document, they also has inherently has the aspect of copyright protection associated with it. Okay. When you file for a patent application, again you do not publish your patent application. The government office publishes your patent application. The patent office publishes your patent application. Okay. So there is an understanding that the copyright to that particular publication is with the government. The government will publish. Okay. But the idea which is involved in that particular expression of your patent, as it has been written, the idea which is already existing, that idea cannot be practiced by anyone else. Okay.
Yeah.
That idea is being protected in the form of patents.
But can I add something?
Yeah.
Within 1 year of publishing the research, I can apply for patent.
Yes.
So now, if when I publish it in a journal, I'm giving the copyright to the journal, but within 1 year I can also apply for patent for the same research product.
Okay, now this is a wonderful scenario. Thank you for pointing it out. That is why India is a sovereign country. The government can do anything. The government's rights are always superior. That is the way to understand what is the meaning of sovereignty of the nation. Even if the publisher has the right, doesn't matter. The publisher is not of the government. Government can do anything. Government can still publish it once again. Got it? Me and you cannot do that. Okay, but the government can do that. You cannot question the government on those terms. Understood?
Okay. Yeah.
Okay, let's, further questions?
You are answering that if an invention or if any information about the patent is published in a journal and is published from the journal.
Rajeshri, you are not audible properly.
Okay, tell me now.
No, very slow. Low. May try increasing your volume in your system.
So can you hear me now?
Yeah, it's better. Yeah, please tell me.
Yeah. So you were saying that if any information with regard to a patent gets published by the publisher in a journal, then that will not be okayed as patent information, right? Because it all happened via consent. It happened via consent.
Okay.
So that cannot be section 29, right? So, anticipation by previous publication. It can't attract section 29, right? That's my question.
Okay, you're going to section 29, anticipation and all the stuff. We'll come to it later on, okay? Let us not...
Sir, I can't hear you. You're on mute, sir.
Am I? Can all of you hear me?
Sir, I cannot hear you.
Others, please, please chat. Am I audible to everyone?
Sir, you are not audible. No, sir.
Just a minute, let me check. Hello, am I audible now?
Yes.
Okay. Since when I have been not audible?
Like from the beginning.
After her question.
Answering.
Okay.
Yeah.
Okay, so section 29, you are going to section 29, Rajeshri. We will go back. We'll discuss on your question. Please.
Yes, sir. I understand, but then I was just like, what if I forget my doubt in case?
Yeah. Please put it in the chat. That's all I remember. Please put it in the chat or send a WhatsApp message to me. Okay. Better you put it in the chat.
Okay, I'll send a WhatsApp.
I will definitely discuss this in due course. Okay.
I mean, once the program ends, the whole chat will end, right, sir? I'll text on WhatsApp my query.
Okay, sure.
Thanks.
To be very frank enough, I did not get your doubt properly, but I can understand that you are asking something in relation to section 29 and the publication. I will definitely get back to you once I get your question properly. Okay, but right now we are at the very basic levels. We are not.
Yes, sir. Yes.
Okay.
I understand.
Okay, fine. So let us start with patents. If you are already tired, then you need to get more tired today, because every day session will be of minimum 2 hours. So please, each session will be of minimum 2 hours. So please come here with that particular mindset only. You can take break at your own will, and you can these videos will also be available in my YouTube channel. So you can also refer to the videos later on. Okay, but please attend them live. That is gonna be more beneficial. There is very less time remaining, and if you again keep something for later, then there will be no more time available to you at all. Okay, because there is only countable days now, 7 days. Okay, now patents. What is the subject matter of patents? Patents are applications of science and technology are the subject matter of patents. As I have already said, eligibility criteria of patents are novelty, inventive step, and utility. I believe all of you present here
Yes.
might be knowing this.
Yes.
Novelty, inventive step, and utility. Okay. Subject to the due process of law, that is the patent examination. You will get a patent only if the patent has been examined, and you have to undergo a specific process which has been written, which has been codified in the Patents Act 1970 or patents not or and patent rules 2003. Okay, Patents Act, all of you write one thing, right in the chat box. All of you just write this as I am typing. Just write this as I am typing. This is very important, very important. Just see what I am typing and type it back. Okay. Just a minute. Even I have to confirm before I give it to you. Yeah. Just a minute. Yes, everyone type this. Type this. I want to see how much you can replicate. Exactly what I have typed. Be very careful with the punctuation marks. Type this, everyone, please. Even if in your mobiles, please type it. Type it. Very important. This is very important. On this aspect only, you will lose 20 of your marks in the paper, in the patents paper, out of 100. Just type it out. All of you. All of you here, type this out.
Which one? What to type?
I have written something.
It
Just
is
follow
not here.
others. Yes, just follow. Don't copy paste. Please don't copy paste. Type it
No,
out.
it has not come. Your rating.
See in the chat section.
Oh no.
Okay, others.
Oh
are
yeah.
Others are typing it out.
Yeah.
Please don't copy paste. Please, all of you, don't copy paste. If you are trying to be clever, you are just going to be clever with you, not with me. Okay, it is for you. Just type it out as I have typed it. Exactly. There are still mistakes. Sri Lakshmi mistaken. Suraj is mistaken. I will say what is the mistake. एग्जाम में चीटिंग करने के लिए दे रहा हूँ यार. चीटिंग तो ठीक से करो. All of you, type it out. There are 14 participants. Others, please. No one is special. Even if you are a patent agent now, even I have also typed it out. Before typing it out, I have confirmed. See, that is my status. 90% of the people will do this mistake in the exam paper. We will not write the Patents Act and patents rules properly in the exam paper. That means you are not referring to the correct act and you are not referring to the correct rules. You don't know what to refer and you are giving patent agent exam. So please, how many people have typed in? Let me see how many answers did I get. Devosrita Bashak. Madam Devosrita, can you please speak up? Devosrita. Anyways, no problem. See, before we go to the patent agent exam, this is what is your syllabus of patent agent exam. Not Patent Act,
Patents Act.
okay, not Patent Act 2005. So many people will say Patents Act 2005 or Patents Rules 2021. Okay, you might say that because all of these things you might be seeing if you have been studying by yourself by now. No such thing at all. Exactly what I have written. By default, use this Patents Act, 1970 and the Patents Rules, 2003. Use this phrase in each of your answers as many times as you can. Okay, or you can do one thing, in each and every question, answer to your questions, you can write it according to the Patents Act, 1970 and the Patents Rules. The Patents Rules, if you don't give the doesn't matter much, but there should not be any mistake in writing Patents space Act. P and A should be capital letters, comma, space 1970, space and space the Patents space Rules, P and R capital, comma, space 2003. According to this, then start your answer. Okay, and say hereinafter the said act and the said rules. Just I am putting it in the chat. Start your answer with this phrase always. Start your answer with this phrase always. Many of you will miss it. This creates a impression, first impression. Even if you answer wrong or you are not answering properly to the point, then if you would have got 2 marks out of 5 marks in one question, if you have written like this, the examiner will give you 1 more extra mark. Because in the very beginning only he has his mind, in the subconscious nature of his mind, has accepted to give you this 1 mark extra. Because you have written this. According to, you have written the words correctly. The Patents Act, comma, space 1970 and the Patents Rules, space, comma, space 2003. Okay? Don't mess with this phrase at all. You should write 20 or 30 times by yourself in your piece of pen and paper that you are holding right now afterwards, before you leave this session. After the session is over, write this: the Patents Act, 1970 and the Patents Rules, 2003. Okay, this is very, 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 very important for your exam, and most of the examinees are unaware of this. Most of the examinees. Okay, fine. So these eligibility criteria of novelty, inventive step and utility, as you can see in this slide, are provided in this particular act. Act is a, जिसको बोलते हैं कानून. हाँ, कानून बनाया गया हमारे कंट्री के लिए, for our country. In our country we have to abide by this particular act, which has been made by the Constituent Assembly, the legislature, okay, the Lok Sabha and the Rajya Sabha. उन लोगों ने बना के ये चीज़ लिखा है, लिखने के बाद डिस्कशन हुआ है, डिस्कशन होने के बाद it went through the both of the houses and then it got assent of the president, then it became an act. Okay, ये particular specific act बना है पेटेंट्स रजिस्ट्रेशन के लिए, पेटेंट रजिस्ट्रेशन का प्रोसेस फॉलो करने के लिए, या पेटेंट्स से एसोसिएटेड कुछ भी मैटर हो उसके साथ डील करने के लिए. फॉर दैट रीजंस दिस पेटेंट्स एक्ट हैज बीन codified as a statute. So you should refer to the exactly the same statute which is relevant. When you miss up with any s or space, commas, okay, or the year in which the Patents Act was codified was notified and commenced, एवरी एक्ट का पर्टिकुलर सेक्शंस का या फिर एवरी एक्ट एज ए होल का एक नोटिफिकेशन डेट होता है फ्रॉम विच दैट एक्ट बिकम्स एनफोर्सेबल. ओके, सो फ्रॉम दैट डेट स्टिल नाउ दिस इज ए कोडिफाइड statute and that statute needs to be referred correctly. If you are not writing those statutes properly, then you are not referring to the proper act and you are not referring to the proper again the statute itself. You are not referring to the proper statute itself, so your answer might be considered not proper. The answer might even be considered completely wrong, because in our country there is no such act like Patent Act. Okay, there is no such act like Patents Act 2015, or there is no such rules like Patents Rules 2020 or Patents Rules 2021. Yes, there have been so many amendments, serial amendments in the Patents Rules space 2003 in different years. In 2020 and 21, in 21 there has been 2 times the rules have been amended. Okay, amended means new incorporations or substitutions in the rules have been done. There is a difference between act and rules. I will tell you. I have also said you that in my earlier session. It is there in the YouTube. The difference between acts and rules. Okay. So unless you refer to the proper statute, your answer is by itself becomes wrong. You will only get concession marks. So whether you want to get concession marks or you may not get mark at all. If I had been the examiner, I will just strike out. I will not look at my time is very precious. I will not give one single extra moment to see that answer at all, even if you have written correctly. Because you have not written, if you have not referred to the act properly, I will not find any such act in my country. You understand the importance of why I made you all of you to write like this. The Patents Space Act, 1970 and space dena the Patents Space Rules, 2003. Okay, there is a particular different way of writing the rules. There is a particular different way of writing the rules, okay, to refer to the amendment of those rules in that particular year. I will not tell that today. I will tell it when it comes into application, because I don't want you to confuse with the different years of the rules. So many people will write patent rules in different years. Somebody will write 2007, somebody will write 2011, somebody will write 2015, somebody will write 2021, but actually all of them are wrong unless you write like this: Patents Rules space 2003. This is the basic set of rules which has been amended. So if you remember 2003, 1970 for the act and 2003 for the rules, then you will never be mistaken. Okay, you can say according to the latest amendment of the Patents Rules, space 2003. You can say like that. And you can refer to the latest amendment, whatever your answer is. That will not be wrong. You need not say that which year it has been amended. Exact year need not be said. Only the subject matter of the amendment should be correctly written. And you can just write patents rules space 2003. The examiner cannot cut your marks for not writing the year of the amendment. But you have to write it like this: the Patents Act, comma, space 1970, and if it is regarding the rules, the space patents space rules, comma, 2003. Okay, so this due process of law, renewals of, getting back to the slide, renewals of the patents, territorial nature of the patents, eligibility criteria of the patent, everything is there in this Patents Act 1970 and the Patents Rules 2003. Everything is there only, and that is the syllabus of your this exam. Okay, fine. Okay, why is this not slide move? Okay, yes, you are going deep slowly. Okay, and from now on your copy and pen will be very essential for all of you. Your copy and pen is going to be very essential. What is the meaning of patent? I will not go to this slide. I don't know how many of you have seen. What is the meaning of your patent? Only 7 days remaining to the exam. I want to know what have you prepared out of yourself till now. What is the meaning of patent? Anyone? Anyone, can you define patents?
Yeah. Shall I?
Yeah, please.
Patent is a right for a stipulated time given to the first inventor of the application on a based on territorial right.
Yeah, it is a correct answer, but not correct for the purpose of patent agent exam.
Yeah.
No, I don't want to discourage you. Please don't get me wrong. I understand. I completely appreciate your efforts. No one of here is putting the effort that you are putting here, Dr. Basu. I really appreciate. Thanks a lot for that. Okay, I really appreciate your interest and the time that you are giving at this moment of late at night. Thank you for that. Thanks very much. But others, please try to define what is patent. What is a patent? Say something. You must have known, must be knowing what is a patent. Naveen, tell me what is a patent. I don't know how many are still there. Dr. Samrat, please tell me what is patent. Nice to see you, Samrat. When did you join? नहीं खोलेंगे, नहीं बोलेंगे. टीचर पूछ रहा है देख के, लास्ट बेंच से उठा के. Yeah, Srinivas, please tell me what is a patent.
So basically, it is a legal right what it has been confirmed to an inventor, and to qualify as a patent or a subject matter of patent, there are the 3 qualities or the properties which has to be qualified.
No, stop. Okay, I got your answer. Irrespective of how much ever you write, I'll give you only 1 out of 5.
Sir, it is a legal right given to an invention for its commercial use, sell,
Okay.
etc.
Okay. I appreciate your efforts. I don't want to discourage any one of you. I was just joking. Okay, please don't get me wrong. But the answer to the questions for the purpose of this patent agent exam is this: section 2, section 2 in bracket M. It is not subsection M. Okay, clause M. Section 2, clause M. Definitions are always provided in section 2 of the act, of any of the act. So even if you don't know what is a patent, if you write only section 2 clause M of the Patent Space Act to 1970 and patent rules का जरूरत नहीं है. Only if you say section 2 clause M of the Patents Act 1970 is a patent. Correct answer. I'll give you 4 out of 5. You need not say what is a patent. If in the patent agent exam they say what is a patent, go to the definition of the patent that is given in the Patents Act itself. Okay, patent, and then be very, very careful in defining any particular. Okay, Rajashri, thanks for the. Yeah, Devasita, very good, Devasita. Patent is a statutory right, correct? Patent is a statutory right. Patent is and only is statutory right. Okay, as I said, registrable intellectual property. Okay, so for the exam, you should write like this. Patent means. You should write always. Patent means. Not any other. Patent is defined as patents. Patents are those, or patents are given, or patents blah, patent this, patent that. Nothing. You should say patent means, because in the act it is said like that, and it is a legal definition. It is a legal definition under the act. The act which itself is the syllabus of your exam. Okay. So you should write patent means a patent for any invention granted under this act. And what is this act? The Patents Act 1970. This will take you to 5 out of 5. टीचर को कहीं से, एग्जामिनर को कहीं से मौका नहीं मिलेगा आपका मार्क्स काटने के लिए. इस particular question में you don't need to explain or include in your answer the eligibility criteria of patent. You have to only say what is a patent. And for the purpose of exam, everything relates specifically to the act. I understand now in these 7 days it is not possible for you to mug up the entire act. Okay, it is not even possible for me to mug up the entire act for the last 12 years. Okay, but the benefit that you will have of having my sessions attended for the next 7 days is you will know what definitions will be asked to you in the exam. Most likely. Okay, if I will go through at least 6 or 7 definitions, and out of that at least 4 or 5 will be useful in the exam. Okay, so please be with me in the sessions, and there are so many definitions in the act itself in section number 2. Okay, so you don't need to mug up all of them, but the really important ones, whenever you get an opportunity to define it in any of your answers, just define it. It is another opportunity to drag impression of your examiner. ये patent section 2M तो रट लो बार 20 बार लिख लेना अपने एंड पे. Patent means a patent for any invention granted under this act. Patent means a patent for any patent is defined as wrong. Patent includes wrong. You should say patent means. Okay, there is a difference between includes and means. Includes, when in some of the definitions it will start with the phrase includes. In some of the legal definitions it will start with the phrase means. Okay, when it is starting with the definition means, then it is very rigid, it is very specific. Okay, it means and means it is only that thing that is what is referred to legally, no any other thing. So anything, if you are defining in legal terms, you should draft it as either patent, either something with the phrase means or with the phrase includes. definitions other than starting with means or other than starting with includes is wrong under the legal perspective. Okay, so in this exam you have to write legally, your answers should be legally acceptable answers. Okay, that is what will raise the standards of your answer paper. Okay, so you should anything, even if the question is not asked what is patent, if it is not asked like that, but in any of your answers you want to include the definition, just pour in your knowledge there. 2M, refer to the section 2 clause M. You can write it like this. I am writing in the chat box. You may not write 2 clause M, you can simply write as 2 bracket space M, like this. Section 2M defines, section 2M of the space Patents Act, 1970 defines patent. Okay, now the next thing is, so everybody is clear what is patent? Patent means a patent for any invention granted under this act. See, the definition also includes the word patent. The legal definition does not bother, the legal definition does not bother to define, to mean what, means to explain what is patent here. It says patent means a patent for any invention granted under this act. If there is any invention and it has been granted as a patent, that is a patent. And how to write it? There is no other way to write it. You should write patent means a patent for any invention granted under this act. Many of you might be finding it boring that I am repeating the same thing once time and again. But I really want this thing to get into your brains. Section 2(1)(m). Well, did I commit the mistake? Section 2(1)(m). अभी देख लेते हैं, just a minute. Thing is, I have only prepared the slides long in the month of January, but I could not share with you all. But when you say 2(1)(m), I myself is getting confused. Just a minute. Correct, 2(1)(m). Agreed. Section 2(1)(m). Thanks for the correction, Srinivas and others as well. Thanks very much for the correction. Also, Sri Lakshmi, very good. I really appreciate it. But remember this in your exams, that you have to refer to the sections. Only those important sections. All the Patents Act sections need not be remembered. Okay. As far as definitions are concerned, you must write exactly what the definitions is. Other portions of the sections you may write, if you cannot replicate exactly the language of the section, you can write what the section exactly means. Okay, so what the section exactly relates to. Okay, explain it in your own words, but mention the section number properly. It is not even required to mention the subsection number properly. At least mention the section number properly. But for the definitions, section 2, subsection 1, clause M, it is required. Section 2, subsection 1, clause M, for only the definitions, exactly the same section number and the subsection number and exactly the same definition is required to be replicated in your answer paper. Okay, so next important definition which might be asked is Invention. Okay, other important definitions I will definitely say later on, but let us go and try and understand legally what does that patent means. Okay, so in section 2(1)(m) says patent means a patent for any invention granted under this act. Okay, thereafter next thing is, what is invention? Invention is also defined under this act. Okay, now section 2(1) clause J defines what is invention. 2(1)J, 2(1)J तो हमको इतना बार काम में आता है अपने लाइफ में, 2(1)J and also 2(1)JA. Okay, because invention is defined as, invention means a new product or process involving an inventive step and capable of industrial application. See, there itself are the patent eligibility criteria being incorporated in the act. Invention means a new product or process involving an inventive step and capable of industrial application. So, invention, for invention, what are the criteria? It has to be, number one, a new product or process. That means novelty. Where is novelty written? It starts with clause section 2(1) clause J. Section 2 subsection 1 clause J. Novelty starts with section 2 subsection 1 clause J, wherein invention is defined. And in order to define invention, the Patents Act 1970 says invention means a new product or process. That means patents can be granted, can be registered for a product or a process. Okay? Going further, what that product or process has to be, what are the additional features that product or process needs to be satisfied with? The additional features are, the new product or process must involve an inventive step. Must involve an inventive step.
Innovative.
No, not innovative. Don't confuse.
Okay.
Inventive step. Get it as it is. Inventive step. Innovation is completely a wrong term. Innovation does not have inventive step. Innovation does not have inventive step at all. In the market, in colloquial usage, we use the term innovations. Okay, but legally there is no definition of innovation. The way to understand innovation is something new without the inventive step. That something which is new, a product or process can be new, but it does not have inventive step. So it is an innovation, it is not an invention. On this note, you have got a difference between innovation and invention, which might even be asked in the interview. Okay, so invention means, what is an invention? Invention means a product or process. That means an invention can be a product, an invention can be a process. Okay? Either it is a product or process, it must and should involve an inventive step. And it must and should be capable of an industrial application. So section 2(1)J defines all the patent eligibility criteria: novelty, inventive step, and industrial application. Okay. Now the next thing is, what is inventive step? What is inventive step? Inventive step is, again, I am explaining inventive step is, but when you write, you should not forget to write your answer as inventive step means. Inculcate this habit of defining legal terms only with respect to either means or includes, nothing else. Means or includes. Term means The term includes. Now what is means? Means is exactly the same thing. And includes in some definitions it starts with the phrase includes, that also means exactly the same thing. But unfortunately that cannot be defined properly in the English language, so it is defined in the nature of the examples only. It is defined in the nature of the examples only, and only those examples comes within the ambit of that particular definition. No other things. If I say legally a container includes a cup and a glass, okay, then anything other container, for example, even a plate is also a container. The plate is not falling within the definition of a container. That is the reason of defining legally in the nature of includes. But most of the times definitions generally start with the phrase means. Okay, if it is not possible to define as means, then legally it is defined as includes. Now when you write in your paper answers, you should write in the same way as it is defined in the Act, at least for the definitions, only for the definitions. For other things it is not required. Don't get scared. Only for the definitions, and definition under the Patents Act 1970 and definitions under the Patents Rules 2003 are nominal. Important ones we will discuss. You have to mug up. You have to memorize. Definitions only you have to memorize. For other things, only the section numbers you have to memorize and the gist of the section you have to understand. But the section numbers you have to memorize. Not even the subsection numbers. People start getting confused with the subsection numbers and say, oh my god, I cannot remember the sections and subsections. But that is not required at all to pass any legal exam. Only the section numbers are required. And then you have to explain what is given in the section in your own understandings. That is all right. But you should say and explain properly. Not say or explain something which the section does not say at all, or you should not try to as such that what is a patent, there you start defining, you start including in your answer what are the criteria of the patent. Not required. Don't say more than what is required. Okay, so again let us come back. Patent means a patent for any invention granted under this Act. It is defined in section 2(1)(m). Then, since invention is mentioned in 2(m), let us go what is there in the, what does it mean, what invention means. Invention means a new product or process involving an inventive step and capable of industrial application. That is section 2(1)(j). Then, what is the meaning of inventive step? This inventive step is also defined in the Patents Act 1970 in section 2 subsection 1 clause JA, which defines inventive step. Very important definition. All of you 12 people, 10 people present right now, write it in the chat box. Copy, don't copy, just write it in the chat box exactly what is written. All of you. With this we will close the session. The next sessions will start with all the relevant subject matter completely. Please write this. All of you, I should get 10 answers. Inventive step means exactly, copy it. copy, I mean type it. I mean don't just copy paste. Type it. Also with the correct punctuation marks. If you are doing it right now, you will not do the mistake in the exam. If you are typing inverted commas with inventive step right now, you will not forget to do it while you are writing in the exam. That is why I am asking all of you to type it out. Rajeshri, we are closing. Anyways, we can leave. I'm not going to add something to after this slide. We can go. Thanks for attending. I believe all of you are typing it. You can put your cameras on, please.
Yes, typing.
I know, Dr. Basu, you are visible. You are the most attentive, my most favorite student in this session. Thank you. Thanks a lot. Thanks for your attention. But all of you others, please put on your cameras. Don't hide behind the cameras. Please put on your cameras. Type it out. Srilakshmi, all of you, please put on your cameras so that I can see everyone typing it out. Okay, Dr. Sama, thank you. No, I asked you to type in the chat box, not write it. Type in the chat box. Dr. Samba, Nehua. As usual, Dr. Basu is the first person to answer. Okay, not invention. Dr. Basu, I wanted you to type inventive step. Inventive step. Inventive step. Not the entire thing. Only inventive step. All of you, only inventive step. Yes. Aditya. Inventive step means a feature of invention having technical advance as compared to the existing knowledge. Okay. Or having economic significance, or both. Good, Sri Lakshmi, very nice. You have given the inverted commas. I was in Devasrita's answer, inverted comma was missing. There is a reason why should we put inventive step in under inverted commas. That means we are referring to exactly the same thing what the act means. That is why inverted commas is required. Okay, so please, if it is a definition, the number of times you are using this particular word inventive step in your answer paper with respect to any other answers, you can put inventive step under inverted commas. That means that inventive step is defined under the act. Exactly under the act it is defined. It is not something which you are personally referring to. You are referring to that specific definition what is defined in the act by itself. That is why you should practice writing under inverted commas inventive step. If you practice these habits, the examiner will definitely look at your answer sheet with greater attention and with good impression. And always with the what should I say? In the habit, not willingness, with the willingness to give you more marks wherever possible. You should make the examiner feel like that seeing your paper. How can I give more marks to this particular answer? Okay, it's not like school paper where the answer paper is shown to you. So you have to shoot really well in your answer so that it really impresses your examiner. So these are the tactics. Even if you don't know the answer, you have written something under inverted commas, you don't need to remember any section only. Just write inventive step under inverted commas. People will understand, the examiner will understand this person has good legal aptitude. And this is a legal paper. Okay, now let me define just inventive, make you people understand inventive step, and we will close the session as of now. Okay, so inventive step means इसमें दो कंपोनेंट चाहिए. दो कंपोनेंट क्या चाहिए? टेक्निकल एडवांस. ओके, आइदर इसमें टेक्निकल एडवांस हो सकता है और सी हियर और, नॉट एंड, और मतलब आपके इन्वेंशन में, इन योर इन्वेंशन it can either constitute of any technical advance or it might have some economic significance. टेक्निकल एडवांस भी हो सकता है, इकोनॉमिक सिग्निफिकेंस भी हो सकता है. एनी वन ऑफ दिस टू हो सकता है, एनी वन ऑफ दिस टू. सो नॉट नेसेसरीली योर इन्वेंशन हैज टू बी technically so much complicated always to satisfy the patent eligibility criteria. It can be simple incorporations of technology, but it must and should have economic significance of that technology. Okay, technical advancement होना optional है. अगर technical advancement नहीं है, if it is not having the technical advance, it must and should have at least economic significance. That means, when I say economic significance, it means it should be cost effective, or in simpler words, it should be cheaper. It should be cheaper comparatively. Comparatively cheaper to what? From what are we comparing? To existing applications of technology for the same purpose. To existing applications for the same technology, to the existing solutions compared to the existing applications of the same technology, or compared to the similar applications of the same technology as is known in the present. Compared to this, your applications on science and technology should be cheaper. Understood? That is the meaning of economic significance. Or alternatively, your invention can possess some technical advancement. Now the technical advancement, it is a very subjective term. It is not defined at all anywhere, technical advance. It depends upon you how you establish the technical advancement of your invention, of your patent. And that is what you have to include the manifestation of this technical advancement through the scientific experiments which must be included in the patent drafting exercise, in the patent draft that you write. What experiments would establish the technical advancement? You have to assess as a patent lawyer and include it in the patent draft, which is also called as the patent specification. So in the patent draft, this inventive step should be realized in the form of either technical advancement or economic significance. Okay, you can say why or how it is economically significant, or you can also say how it is technically advanced. Then and only then you satisfy the first set of criteria of inventive step. The first set of criteria. First set of criteria are either of technical advancement or economic significance. What is the second set of criteria? Second set of criteria is either it is a technical advancement or it is economic significant, they should be, any one of these or both of these should be not obvious to a person skilled in the art. Not obvious to a person skilled in the art. Not obvious. Not obvious means something surprising. Something surprising which the people in general or the people having ordinary skill in the art, people having ordinary skill in the art, meaning thereby people who are dealing with that applications of science and technology in general, only for those people, your invention should have some surprising nature. Okay, that means you must write it, the surprising nature, exactly as it is written in the section, in the manner of not obvious to a person skilled in the art. Not obvious to a person skilled in the art. Inventive step means, now remember, even if you don't, if you cannot exactly replicate what does inventive step means in the paper, then at least refer to the section number properly, that is section 2 subsection 1. Section 2 subsection 1 clause JA defines inventive step, and inventive step means definitely write means, inventive step means a feature of an invention that involves technical advance as compared to existing knowledge, or having economic significance. If you don't remember that much, if you just write section 2 subsection 1 clause JA, means inventive step is defined in this section 2 1 JA, full stop. Inventive step under inverted commas means invention having either technical advance or economic significance and not obvious to the person skilled in the art. That is the simplest and correct definition of inventive step, if you cannot exactly replicate of what is written here. इन्वेंटिव स्टेप के अंदर दो सेट ऑफ क्राइटेरियाज है. पहला क्राइटेरियाज के अंदर है टेक्निकल ऑल्टरनेटिव आइदर ऑफ द वन क्राइटेरिया से पहला वाला में, दैट इज टेक्निकल एडवांस और इकोनॉमिक सिग्निफिकेंस, एंड whether it is technical advance or economic significance, any one of those, but must and should be not obvious to a person skilled in the art. Technical advance or economic significance and not obvious to the person skilled in the art. These are the key terms for defining inventive step. Understood? So having that said, try to remember these three definitions, section 2M, 21M, 21J and 21JA. Definitely they are going to be useful for the exam. Definitely. They are going to be directly asked, or you can show your knowledge of these particular definitions in the paper, which will create the impression on the examiner while he is trying to assess yourself through your answers. Okay, sessions are available in the YouTube. Tomorrow morning at 6 o'clock we'll start again, so go off to sleep right now and wake up early again. Okay, sorry to bother you, and I believe you found these sessions interactive and adding some value to yourself.
It is 6
Sir,
to 8.
we'll be joining in the same link.
Yeah, the link will always be same. I will not change the link. The meeting
It
link
is
will always be the same.
6 to 8, no?
Yes. Mr. Rocky, if you want to file a patent, call me. I am giving my phone number here. Or write to me here. Does anyone have the examination center based out of Chennai? If yes, we can connect. Yes, no, okay. Okay, so thank you very much for coming in. And
Thank you.
definitions are really important and time taking. I will try to, because it is difficult to remember, but if you remember the essence of the definitions, like as I broke section 2.1j into two first components and then two components in the first component separately, right? So that's how, if you try to remember, it goes inside your mind. You can replicate 70 to 80% of it. Okay, inventive step means, inventive step जरूर आएगा, आप लिख लीजिए. इन्वेंटिव स्टेप बिना जो पेटेंट एग्जाम हो ही नहीं सकता है. Rocky, you can also share your number with me, Mr. Rocky. Put in here, I will note it out. Okay, thank you. I'm signing off. Thanks a lot. Bye bye. Good night. Meet you all at 6 o'clock sharp. Good night.